Welcome, Dr. Shetty, to the 50th episode of Editor Speaks. Let me ask a simple question. Is a hospital bound to accept each and every patient that seeks admission? Or are there exceptions?
Hospital has a right to refuse patients. The only exceptions are going to be emergencies. Elsewhere, they have the right to refuse a patient if their beds are full. The reasons has to be justified.
So what I understand, a hospital has an absolute right to refuse a patient, except for emergencies. Let me address a different issue. Private hospitals enroll under government schemes and then later on refuse patients under these schemes. What is the legal stand on this?
See, if the reasons are because of financials, then it is not going to be accepted in a court of law. In a recent judgment from the Punjab State Commission, a patient was transferred from an army hospital to the super specialty of a better management. The patient was refused admission by the super specialty hospital. They said that their beds were full. They referred the patient to another empaneled hospital. There too the reason given was the bed was full. The patient came back to the original hospital and the patient was stabilized and the patient was admitted in a third empaneled hospital where the patient died. The relatives filed a case of negligence. They stated that the refusal was because the government scheme, the fees and the charges were less compared to private patients. And they were refused admission because they wanted to cater to private patients where the charges were more. The hospital took the defense that the reason was not that the beds were really full. But when the hospital was asked for medical records of the day's admission, the hospital did not provide the same. Hence, this raised the suspicion of the court and the court held the hospital negligent.
So the consumer courts can demand details of admission of a particular day if they want to check the details.
They have every right to. How do you check up on whether the hospital beds were full? You have to check on the admissions on that day, whether the beds were all occupied on that day. Hence, my advice to hospitals will be, please keep a record of the admissions and the discharges on that day. Whether the ventilators were occupied, all the infrastructure was used up, or there was any lack of infrastructure was the reason was a refusal was made. Courts are going to look at it with a very fine tooth comb.
So if an impaneled hospital refuses admission to such a patient, it is bound for legal trouble.
Of course it is going to be. Courts are going to be very harsh if they feel the hospital has refused a patient for reasons other than medical or justifiable reasons. If the courts find it that the empaneled hospital refused the empaneled patient because of reasons of money, courts are going to be harsh. In fact, they are going to hold the hospital negligent. They may even make them pay a very high compensation and may ask the government authorities to depanel the hospital from that government scheme.
And what if a hospital is genuinely out of ICU beds? Will it still be held liable?
Of course, the point is hospital beds may be full. There may be epidemics, there may be pandemics. There are times when the hospital is full. But then the hospital will have to explain and prove to the court that their beds were full. For that, they will have to maintain the medical record, they will have to maintain their patients, how many patients are there on ventilators, they will have to maintain the admission record, whether any patient were discharged. All this will be looked at closely by the courts. Courts are going to be kind to hospitals. They also understand. There are times ICU beds may be full, but at such times, if the courts find that there was some hanky-panky, then the courts are going to be harsh.
Thank you, Dr. Shetty, for an important learning.
Thank you.